Okay, good morning, and thank you all for attending our webinar on navigating Canada's Supply Chains Act to fight against forced and child labor. My name is Maria. I am the marketing manager at GHY International, who will be moderating today's webinar. So some quick notes to start. We encourage you to submit your questions throughout the webinar as they arise. You can do this by clicking on the chat icon marked with the question mark on the right-hand side menu of your screen and type your question. We will address these during the question and answer session at the end of the presentation. After the webinar, we will send a follow-up thank you email with links to access the recording of this webinar, the slide deck, some helpful resources, and contact information. This session will focus on critical elements of Bill S-211, an act to enact the Fighting Against Forced Labor and Child Labor in Supply Chains Act and to amend the Customs Tariff, which serves as a significant milestone in the fight against forced labor and child labor within Canadian supply chains. So we are delighted to welcome our guest speaker and subject matter expert, Jessica Horwitz from Bennett Jones. Jessica is a Canadian international trade lawyer. She advises clients on a broad range of import and export related matters, including compliance, audits, and resolving disputes before the Canada Border Services Agency, the Canadian International Trade Tribunal, Canadian and provincial courts, and other government agencies and international organizations. Al Duer, our second speaker, is the Executive Vice President at GHY International. Starting in operations in 1982, Al now leads GHY's One Border, One Broker service initiative. As a certified trade compliance specialist and now customs broker, he has played an influential role as the national director and former chair of the Canadian Society of Customs Brokers and continues to serve on its executive committee. So without further delay, we will now move into the presentation. Jessica, please take it away.
Thanks, Maria, and thank you everybody for joining today. So I'm going to start by giving an overview and discussion of the applicable laws in Canada that relate to forced labor and child labor compliance, including the new Supply Chains Act that came into effect on January 1st. And then Al is going to follow with some comments about the practicalities of compliance with these laws and how to address that with your customs broker, and specifically what types of tasks should be delegated or handled internally. And then hopefully we can leave a good amount of time for questions at the end to discuss some of your burning questions, since I know that the reporting deadline is coming up rapidly. So just to start as a bit of a level set, this session today is about the Supply Chains Act, so the Fighting Against Forced Labor and Child Labor in Supply Chains Act, which you'll forgive me, I will use the short form because that's a bit of a mouthful. So I just wanted to kind of frame the different categories of types of laws that are starting to develop around the world to address concerns about human rights abuses in an employment context and other forms of modern slavery, including things like human trafficking, sexual exploitation, and things of that nature. So there's a few different categories of laws. The first category is import prohibitions. The United States has been actively enforcing its import prohibitions for several years. There are also similar laws in Mexico. There's new laws coming into force in the European Union, and import prohibitions basically say that you as an importer cannot import into the country any goods that are produced in whole or in part with in Canada, it's forced labor or child labor, but whatever the human rights abuse type of conduct that's being targeted by the particular jurisdiction. So that is a regulation that is enforced at the border by the border agency, it can result in detentions, it can result in audits, it can result in importers having to destroy or re-export goods. Canada has had an import prohibition on the books since July 1st, 2020. That was when the USMCA came into force and Canada made some amendments to its customs tariff to prohibit the import of goods produced in whole or in part with forced labor. That was expanded to include child labor with this new Supply Chains Act. But I just wanted to make that very clear that this act that we're talking about that came into force this year is a reporting act, but Canada has in fact had import prohibitions in force for several years. So this is not something that is new. The second category is reporting obligations. So you have similar laws that exist in the UK under the Modern Slavery Act, in Australia under its Modern Slavery Act, in the state of California, and in a number of European jurisdictions. And the purpose of these laws is transparency. It's to require companies to publicly disclose what they are doing or not doing to address human rights concerns in this area. So this category of laws does not impose any kind of hard legal requirements in terms of what you are required to be doing for due diligence. It just says you have to tell the public what you're doing or what you're not doing. And then the third category of laws is what I would call due diligence laws, which does impose hard obligations on the types of due diligence that companies have to perform. So, you know, what kind of compliance programs you need to have in place, what kind of due diligence you're conducting on your suppliers, and things of that nature. Canada does not currently have any laws in the third category. So we've got the import prohibition. We've got now the reporting requirement, which is new this year. And there is discussion in Parliament about the possibility of introducing harder due diligence laws in the future, but we do not currently have that. Next slide, please. So what Canada does have is this new law, that the Supply Chains Act that came into force this year. In addition to introducing certain contingent amendments to the customs tariff and other statutes, the key piece of this new legislation is, as I mentioned, the transparency reporting requirement. So it requires companies to report on what they did to prevent or reduce the risk of forced labor or child labor in the supply chains in its prior fiscal year. The customs tariff has an import prohibition under tariff item 9897, which is one of the special country-specific tariff classification codes that lists products that are prohibited for import into Canada. So it's the same kind of category that would apply to other, banned products or, dangerous items that are not allowed in Canada. The difference is that unlike a switchblade or a pepper spray or something that's obviously identifiable as a prohibited item, goods that are mined, manufactured, or produced wholly or in part with forced labor or child labor is not going to be something that is visible on the face of the product itself. So it becomes a challenging enforcement issue for the Canada Border Services Agency and other Canadian government departments, and also a challenging compliance issue for importers, because the onus is on the importer to determine or to conduct sufficient due diligence to satisfy yourself that you are not importing goods that are tainted in this way. And then I'll also just mention a couple of other categories of forced labor related regimes that we have in Canada. We have an office called the Canadian Ombudsperson for Responsible Enterprise, which is an office that has a mandate to conduct complaint-based investigations into human rights abuses by Canadian companies, specifically in the garment, mining, and oil and gas sectors only. So it's only mandate only extends to those industries at present, although it could be expanded potentially in the future. That is not, the Corps does not have the ability to impose fines or criminal penalties of any kind, but it can make recommendations to the federal government about steps that should be taken. And the biggest risk with core investigations is often reputational, and that it can create a body of evidence that could form the basis for other enforcement action by other government agencies. And then, of course, we have prohibitions under the criminal code on other types of activities that would be included in the broader modern slavery definition, such as human trafficking. But the Supply Chains Act is focused exclusively on forced labor and child labor. Next slide, please. Next slide. Okay, so what is the Supply Chains Act, what used to be called Bill S-211? So it received royal assent last year. It entered into force on January 1st, 2024. An important aspect of the act is that it added a definition of both forced labor and child labor, which did not exist previously under the Customs Tariff. So the Customs Tariff, although since 2020 it has said you can't import goods made with forced labor, we never had a definition of what forced labor actually means, and now we do, which is very helpful from a compliance and due diligence design perspective. It expanded, as I mentioned, the existing import ban to also apply to prohibited child labor, and we'll get to the definition of what that means in a moment. But perhaps the biggest headline item is that it imposes this annual reporting obligation for certain entities that meet certain size thresholds and that have a business presence in Canada and that engage in certain activities that relate to the importation and sale of or the manufacturing of physical goods. It also includes, in connection with this reporting obligation, enforcement powers for the Canadian government. So this was added to the legislation somewhat in criticism of some of the legislation, transparency reporting legislation that exists in other jurisdictions that does not have teeth, so to speak, because there's no ability for the government to impose penalties for non-compliance. This legislation does have a summary criminal offense for non-report, so failure to report, or for the making of false or misleading statements in a report. And that's punishable by a fine of up to $250,000, either against the company, or it can also be assessed against directors and officers or other employees or agents or mandataries of the entity that failed to report. So it is important, especially if you are in management or you're on the board of directors of a company, to keep a close eye on what is being included in a report, because any false or misleading statements could be could come back to you. Next slide, please. So this is the definitions of forced labor and child labor. And I'll just spend a quick moment talking about what this is, because these concepts are a little bit broader than the average layperson might immediately think. When you think about forced labor, you might think about either labor that is compelled without payment, so the concept of slavery. You might also think of the term of a bonded labor, so somebody that has a debt that they have to pay off to the employer, for example, and they're being compelled to work for that reason. But the definition in Canada's legislation is even broader than that. So it's basically labor extracted under any circumstances that could reasonably be expected to cause the person to believe their safety or the safety of a person known to them would be threatened, or that constitutes forced or compulsory labor as defined in Article 2 of the Forced Labor Convention, which includes the types of scenarios that I just mentioned. Child labor is also quite broad. It tracks the International Labor Organization concept of prohibited child labor. Child is defined as somebody under the age of 18 years, which it may not necessarily be consistent with local laws that exist in the relevant jurisdiction where your supplier is located or where the manufacturing facility is located. A lot of countries define as child as being a much younger age, so 14, 15, 16, as opposed to 18. So that's something to keep in mind, that when you're doing due diligence, you don't want to necessarily just say, I want to ensure that my supplier undertakes to comply with applicable local laws, because applicable local laws may not be consistent with Canada's definition of these restrictions. So child labor, any labor provided by persons under 18 that are either provided in Canada and contrary to labor laws in Canada, or that are provided abroad or in Canada under circumstances that are mentally, physically, socially, or morally dangerous to the child. So very broad umbrella definition there, or that interfere with the child's ability to attend school. Or the definitions that exist in the worst forms of child labor convention, which are pull in the definitions of forced labor and modern slavery type practices. Next slide, please. This is just some examples from the International Labor Organization of the types of working conditions that can constitute forced labor. So it is broader than simply, slavery in the sense of working without payment. It can be providing labor under abusive or dangerous working conditions, forcing employees to work excessive overtime that is over what is permitted under applicable laws, forcing workers to work or to not quit through intimidation or threats, and any other kinds of abusive vulnerability. Next slide, please. Again, just on the import ban, before we get to the contents of the reporting requirements, the import ban is enforced as a tariff classification matter in Canada, which means that the onus is on the importer to self-determine what the classification of those goods are. So if you declare a pencil as a pencil in the appropriate classification in the harmonized system, chapters 1 through 97, then, but that pencil was produced at a facility that was using forced labor, then you've actually misclassified your goods. It should have been classified as 9897 and prohibited from entry into Canada. Historically, at least since 2020, there has not been a lot of enforcement activity in Canada, largely because this import ban was new. There wasn't a clear chain of responsibility within the government about who exactly was responsible for enforcing it. There wasn't dedicated funding at the federal level to pursue that enforcement. And I will just flag for everyone on the call today that that is changing. So the Canadian federal government recognizes that there needs to be more enforcement in this area, particularly so that Canada can keep pace with the enforcement that is happening in the United States, because Canada doesn't want to be viewed as a ground for circumvention of the US import prohibitions on, for example, goods manufactured in the Chinese Xinjiang region under the US Uyghur Forced Labor Prevention Act. So we are starting to see an uptick in enforcement activity. The CBSA is responsible for border detentions and also for investigation of the tariff classification declarations. But the substantive expertise for investigations lies with Employment and Social Development Canada, the labor program, which has the substantive expertise about allegations of human rights abuses or forced labor in foreign jurisdictions or in Canada. So the CBSA works with ESDC Labor and also other government agencies to collect intelligence that informs their enforcement activities. Okay, so turning back to the reporting obligation. The Supply Chains Act requires certain companies to file a report by May 31st. And the question is who? Because the reporting obligation does not apply to all businesses, but it does apply to many, many businesses, and perhaps more businesses than you might have necessarily expected it would apply to. So there's two pieces to the reporting trigger. The first is whether your entity qualifies under the definition of entity within the Act. That's condition one. And then condition two is that entity engaged in any activities that create a reporting obligation. So the definition of entity is either it has to be a company, but it doesn't necessarily need to be a corporation. It can be a trust, partnership, or other incorporated organization that is either listed on a stock exchange in Canada. So if you're listed on a stock exchange in Canada, you stop there. You don't have to do further analysis. You have to report if you're doing the activities, or you're an entity at least. Or if it's private company, the company has to have a Canadian business presence. So that's defined as either a place of business in Canada, being a physical place of business, doing business in Canada, which public safety has confirmed in the administrative guidance means carrying on business within the Canada Revenue Agency concept of GST and HST registration. So if you are carrying on business in Canada from the perspective of the CRA in a manner that requires you to register for GST, HST, then that is what constitutes doing business for these purposes. Or the third one is having assets in Canada. And this one is a little bit more amorphous and difficult to evaluate. And we can, if you have specific questions, we can delve into that. But conceptually, assets would be defined as anything that would show up as an asset in the balance sheet of the company. So including ownership of a subsidiary, conceivably in Canada, that has assets. If you have a foreign parent company, for example, that owns a Canadian subsidiary that has assets in Canada, and that subsidiary's assets show up on the consolidated balance sheet of the parent company, conceivably the parent company could have this Canadian business presence requirement. And then if you have the Canadian, go back. And then if you have the Canadian business presence requirement, the question is, do you meet the certain size threshold? So it's based on the consolidated financial statements of the particular entity under examination. Do you meet at least 2 out of these 3 size thresholds? So 20 million in assets, 40 million in revenue, or an average of 250 employees. This is global, not just in Canada. So we're talking about global assets, revenue, and employees for the entity under examination. And you can go to the next slide, Maria, which is another slide that sort of says the same thing as the previous slide. Another thing to keep in mind is that the evaluation must be conducted individually for each corporate entity in the organization. So just because you determine, for example, that a parent company has a reporting obligation, that doesn't necessarily mean that individual subsidiary entities also have their own separate reporting obligation. You would need to look at that subsidiary's financial statements. You don't have to look at the consolidated financials of the parent upstream. You just have to look at the consolidated financials of the entity being examined, and then you figure out whether that entity has reporting obligations or not. Then can you go back, Maria? Sorry, back to the previous slide. So once you've determined that your company is an entity, or you have perhaps multiple entities within the organization that are entities, the question is, do any of those entities engage in a report triggering activity? And so this is producing, selling, or distributing goods, period, because it says in Canada or elsewhere. And I'll get to a nuance in the interpretation and enforcement of that particular provision that's arisen in recent weeks. Importing into Canada, which public safety has confirmed is defined as an entity that has a responsibility to account for goods under the Customs Act. So they're applying customs law principles in determining who is the importer for these purposes. So for example, if you're a Canadian company and you are buying imported goods from a distributor that is the importer, that is importing them into Canada as part of its business, and then it's selling those goods, making those goods available in the Canadian market to Canadian purchasers, and you're purchasing from that importer, you are not importing, notwithstanding that you might be aware that the goods have been imported. So it is an important distinction. Are you the entity that's actually engaged in the importation transaction, the importing activity itself? or controlling an entity. So this 9C trigger is a bit of a backstop to make sure that corporate parent companies are going to have an obligation to make sure that their subsidiaries that have activities in Canada file the necessary reports. Next slide, please. So I'll mention a couple of nuances that have arisen in relation to amendments that Public Safety Canada has made to the administrative guidance in the last couple of weeks. So one of these is that Public Safety has removed a reference to selling or distributing goods in its guidance, where it talks about which entities have an obligation to report. And this has created some confusion because there are contradictions within the wording of the statute itself about the triggering activities for a report and the contents that need to actually be in a report. So I'm sorry, Maria, can you go to the previous slide again? I apologize for jumping back and forth. So Section 9 of the Act mentions that the part, which refers to Part 2 of the Supply Chains Act, that is the part that addresses the public reporting obligation. The part applies to any entity producing, selling, or distributing goods in Canada or elsewhere. But if you, and I apologize, I don't have a slide that has Section 11 of the Act on it, but if you look at Section 11 of the Act, that starts to get into what the contents of the report needs to include. And what that provision says is that the entity must report on steps the entity has taken to prevent and reduce risk of forced labor or child labor at any step of the production of goods in Canada or elsewhere by the entity, or of goods imported into Canada by the entity. So the report contents doesn't actually have a reference to reducing risk in the sale or distribution of goods that were not produced or imported by that entity. And Public Safety appears to be focusing on the producing and importing triggers. At least that's clearly going to be their immediate enforcement focus, is on companies that are engaged in these producing and importing activities. Although I will caution that the wording in Section 9A is still in the statute, and the administrative guidance does not override the statute. So I think that if a company meets the size thresholds, has the Canadian business presence, but is only engaged in the activity of selling or distributing goods and not producing or importing, I would strongly recommend that you speak to legal counsel to talk about the interpretation of the reporting obligation in your context, because notwithstanding the administrative guidance, which is unclear, ultimately, the statute says what the statute says, and if there is a violation of the wording of the statute, there could be a contravention. Administrative guidance also can be amended without notice and at any time at the discretion of the minister. So just a caution there when you're considering relying on the administrative guidance. Next slide, please, Maria. And next slide. So what does the report need to include? So first of all, the report needs to be filed by May 31st, 2024, and every May 31st thereafter. You can file it earlier. The report has to cover the most recently concluded financial year of the company. So if you're filing on May 1st and your year end is April 30th or end of April, then you would be reporting for that year end. If your year end was December 31st, you would be reporting for the calendar year. However, it's important to keep in mind that the practical deadline for approval of the report might be earlier than the date that you need to file the report, because you need to have approval by the governing body of the reporting entity, which in most cases is going to be either the board of directors, or if there's no board, the sole director or the directors of the company. There also needs to be a signed attestation by a member of that board or some other person in the company that has properly delegated legal authority to bind the board in respect of this attestation, that essentially says that the board has reviewed the report, that confirms that the information included in it is accurate and complete, and that the board has provided authorization to the person signing the attestation to do so on behalf of the board. The reports, sorry, just going back to the practical deadline point, your practical deadline might be earlier than the report submission deadline because of board schedules. So if you need to have something in front of your board of directors and you need to have a resolution of the directors to approve the report, you just have to keep that in mind, because depending on the corporate governance practices of the company, those board meetings might be rigid and sort of strictly scheduled, in which case you have to work within that structure. Otherwise, you might be end up calling an emergency board meeting at the last minute to approve, which might not be desirable in terms of workflow. Joint reports are permissible. So if you have multiple entities within the corporate group that have an independent reporting obligation as a reporting entity, you can file a single report on behalf of all of those entities. You can also have a single attestation by the parent company, provided the parent controls all of the other relevant entities. But the big caveat to joint reports is that the statements in the report must be accurate with respect to all of the entities. So if you have a parent company that, for example, has robust compliance practices and procedures and a code of conduct in place, but that code of conduct is not actually in use by the Canadian affiliate or any of the other relevant reporting entities, you might not necessarily be able to use that joint report in respect of all the entities. Next slide, please. So this is, I'm sorry, so I did have section 11 excerpted here. So this is the section that I was referring to, section 11 subsection 1 and 11 subsection 3 are excerpted on this slide. It discusses the mandatory minimum information content that must appear in the report. This is the wording of the statute. The statute does not specify any particular level of detail that needs to be included for any of these points. It just provides that they have to be addressed. And so determining the level of disclosure and the level of detail of the disclosure that you want to include in the public-facing report is going to be an assessment that each company will make on a case-by-case basis. There will be a wide variation in what these reports actually look like. And so if you've seen any reports by companies that have already filed them, or you've looked, for example, at reports that have been filed in the UK or in Australia under their respective regimes, you'll notice that there's some companies that have a report that's 1 page long, and there's some companies that have a report that's 70 pages long and with a lot more detail. And both of those are theoretically adequate to meet the reporting obligation, as long as each of these information items have been addressed in some way, even if it's just to say, we did not provide any training this year. That's perfectly valid to say. For public relations reasons, if there are items that you are not doing, you should think about how to characterize that, because these reports will be public facing and they will be published. They have to be published on the company's website. They'll be published on the public registry. But I just wanted to flag that there is no specific level of disclosure, and Public Safety Canada has made it very clear that companies are not expected to disclose anything in these reports that they consider to be confidential business information. So you shouldn't be disclosing anything sensitive. You don't need to disclose names of suppliers, names of customers, anything like that. It really is up to the discretion of the company about how much you want to disclose. Next slide, please. So just before I turn it over to Al, I'll leave you with this slide, and I think you'll probably get a copy of these slides after the event. These are just some questions to use as a brainstorming tool or as a discussion starter to think about the types of things that your company might already be doing that you could talk about in your report. Companies may have, even if you don't have a specific compliance program that is targeted particularly at forced labor, and you can think about whether it makes sense to develop one going forward, you may still be doing some things that are useful for the report. For example, if you have production or manufacturing activities within the company, if you have a human rights policy or an employee code of conduct, or policies that state that the company complies with applicable labor laws and that we don't cause employees to work under dangerous conditions, we don't tolerate harassment in the workplace, we don't tolerate overtime in excess of what's permitted under local laws, that already is valuable with respect to your own operations. The more difficult thing is the level of due diligence that you perform on your third-party suppliers, which we can maybe get into in the Q&A a little bit, but that will be context specific and risk-driven. So the level of due diligence that's appropriate is going to vary from company to company and from industry to industry, and there is no one-size-fits-all solution. Unfortunately, I frequently receive requests for, give me a one-size-fits-all checklist that is off the shelf and that I can just start using. And I will not do that, and I don't think any lawyer would do that, because I don't want to give you a 20-page checklist for a company operating in a very high-risk industry that is simply not necessary for the risk profile of that particular company. It needs to be tailored. So with that, I will turn it over to Al. I think we have a slide with some FAQs, but Maria, maybe we can come back to that at the end when we have the question session.
Hey, super. Thank you. Thank you so much, Jessica. And, some people are probably wondering right now why I would be starting off a forced labor presentation in relationship to CARM, something that is happening right now from an import standpoint, being CBSA's Assessment and Revenue Management Program. And my parallel to choosing this is it seems that the government has gotten a little bit excited about wanting to have people register on portals. You just heard Jessica make reference to how it's mandatory to in fact register based on your size and scale for forced labor. And it's also, but that's only size and scale. In the case of CARM, it is mandatory if you're importing at all. So certainly anything having to do with forced labor was part of importation. In the case of CARM, if you haven't registered on the portal, you won't be able to effectively import account. And why the other parallels exist there is CARM, it's providing CBSA with an opportunity it's really never had before. They're going to have access to mega data in relationship to the entire importer everywhere in Canada, the entire supply chain, and they'll be able to use that mega data for enforcement and targeting. And never before have we seen this many changes happen in relationship to customs, seemingly all at the same time in this May of 2024. I've jokingly said Mayday, 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 as a result of so much urgency and speed that's occurring there. I really like what Jessica's referenced as to how those regulatory requirements work and the types of questions that you see being asked or needed to be asked as you're evaluating where you sit there. Maria, if I could have you go to the next slide. So here I wanted to touch base a little bit because when we first saw this S211 forced labor coming out, what wound up happening is we had some of our clients calling us and saying, so what can you do for us? What information are you going to provide us to satisfy this request having to do with forced labor? And that's really outside the scope of what a customs broker is capable of doing in in relationship to what your need is. The role of a broker is that of, and our power of attorney indicates this, 7/24/365 across all modes of transport, any import into Canada. You've got us assigning tariff, you've got us evaluating free trade agreements, you've got us looking at valuation. Well, in all of those actions, we're not interacting with members of the boards of your boards of directors or financial statements. You know, that's not saying that there isn't an opportunity to how you can draw upon your broker, whether that be GHY or another broker. That's not saying you can't draw on them to access certain types of data elements or where forced labor may be more akin to be occurring, but it's not something that happens under a regular scope. And we quite frankly advise consideration to professionals like Bennett Jones and Jessica, who they have a higher standard of care, particularly if you find that you do have a concern that needs to be looked at in that regard. We recommend also that even within the statements of work or the standard operating procedures that you have in place with your broker, we haven't seen anything like this ourselves as yet within Canada, as Canada's really playing catch up to the United States. But our US arm is interacting or has interacted with issues where shipments have been detained. And it's important for us to understand, as your service provider on that 7/24/365, all modes of transport, if a detention occurs that seems to escalate on the basis of forced labor, who, when, and how do you want to have us escalate that to you, or potentially if you have a direct legal counsel that might happen to be working on that. Maria, if I can have you go to the next slide, please. So what I'm trying to showcase in this particular slide is that a broker can in fact be an appropriate partner in looking at things like doing risks, a risk assessment based on what we understand of your suppliers, your countries of origin, or your product types, putting information together such that you can utilize that as it relates to that particular question section that Jessica highlighted. We can also help you in areas having to do with due diligence in relationship to best practices in dealing with suppliers or conducting audits. We can help you in regards to tariff classification. That's certainly, and anything to do with customs compliance, those types of things are our specialties. Training and education as to how that might relate to some of those questions that Bennett Jones has shown or highlighted there. So a custom broker can be a valuable party and partner in all of that, but we are not able to, and we would never be able to assist you with making an intentional, as Jessica alluded to, attestation in regards to your particular requirements under forced labor. We do have, in regards to information having to do with getting on board with CARM, we do have an outstanding white paper as it relates to the types of impact, increased visibilities, and understandings that can support in your planning, because mega data is going to be something the government is going to be using more of, and we welcome the opportunity to work outside of our normal business process in providing any type of support as you look to filling out this type of attestation. We believe it sure might start with just these larger organizations right now based on the size and scale that does have that mandatory aspect. But forced labor is something we all have to be responsible for regardless of our size. So it's likely that you will see it unfold in the future, crossing all industries and industry segments. With that, I'll turn it over to Jessica, and I would like to ask maybe even the first question, pardon me, turn back to Maria, but I wouldn't mind asking the first question of Jessica. I might have missed it. What's the, there's a penalty if you don't, if you are of that size right now, and if you don't file, isn't there, as of as of May 31st? Isn't there a fine that could apply?
So it's an offense on summary conviction. So it is not a strict liability fine that would be applied automatically. It is a regulatory offense that is essentially a criminal offense that the RCM, it would be ultimately the RCMP that would be engaged to conduct an investigation and to ultimately lay charges in coordination with the Public Prosecution Service of Canada. But it's a summary conviction offense punishable by up to $250,000 Canadian.
Thank you, Jessica.
Excellent question, Al. Okay, thank you, Al and Jessica. We will move into our Q&A session now. I'm glad we've got quite a bit of time left because we do have some burning questions that have come in. So to reiterate, you can submit your question by hitting that chat question mark icon on the right-hand side of your menu. And so first question I will choose here is from Angela. So what if our vendors refuse to execute and or sign our vendor code of conduct? Do we have to stop doing business with them under the legislation? We haven't seen anything about that.
Yeah, great question. And you're going to hate my answer, which is the typical lawyer answer of it depends. But as for the last part of the question, is there a requirement under the legislation that you stop doing business with the supplier? No. Because as I mentioned at the outset, this is reporting, it's transparency reporting legislation. It is not due diligence legislation. So the law does not actually prescribe anything that you need to do or not do. What you should do will be a question of your risk assessment and a question of best practices within your particular industry. So it could very well be that if a supplier refuses to sign the code of conduct for reasons that give you a red flag in terms of their forced labor or human rights practices, then you may want to consider discontinuing or continuing to engage with that supplier to try and help them remediate whatever the issue is that's causing them to not feel comfortable to sign the code of conduct. But if there is a valid reason why they are resistant to signing on the code of conduct, you might be able to resolve that. So for example, the company might say something like, well, your code of conduct says that I need to comply with Canadian laws, and I'm in a foreign country and my internal compliance practices are not set up to comply with Canadian laws. So I cannot make that blanket statement that I'm going to comply with all Canadian laws, which is a reasonable position to take. And then it becomes a conversation of, okay, well, could you sign, for example, maybe a narrower statement of certifying that we do not engage in any of the following practices, and then you provide the Canadian definition of forced labor and child labor. So to work with the supplier to come up with something that's going to be give them a level of comfort to be able to agree to, and also give you a level of comfort that the supplier is meaningfully reading the code of conduct or the contract clause or whatever it is, acknowledging it and substantively confirming that they meet the requirements. Because if you just have a supplier blindly sign a contract or a supplier code of conduct without reading it, or they sign a contract that references the supplier code of conduct, but you never actually send them a copy of the code of conduct, they've never received it and they've never read it, that's going to be of less value ultimately in terms of demonstrating your due diligence down the road.
Excellent. Thank you very much for the clarity on that. Okay, we're going to go to the next one. We've got a bunch coming in here. If you have multiple entities that individually don't meet the definition of an entity, but combined together meet the threshold, does that mean there is a reporting obligation for each of the entities?
So the answer to that is no, with the caveat that if there is a parent company of those entities that has a consolidated financial statement that includes all of the assets and revenues of those entities, then the parent company may have a reporting obligation. And you can very well have a situation in which a parent company has a reporting obligation, but none of its subsidiary entities individually do. Which would, the next question there would be, okay, well, what substantive content would the parent company need to put in its report about talking about its own supply chains if its Canadian subsidiaries, for example, don't have a reporting obligation. And these are tricky questions that I think would need to be addressed with your legal counsel to talk about your specific facts. But the public safety guidance is very clear that the assessment of whether an entity meets the entity definition is entity by entity. It's entity specific. And you use the consolidated financials of that particular entity under examination. So if that is just its own financial statement, and you might not have audited financial statements, you might, if it's a subsidiary company, you might just have a P&L statement that you use for internal accounting purposes, that's fine. But you just look at that entity's financials, and then you go move on up the chain to a different entity and you do the assessment again with that entity's financials, which might be broader. So I'm not sure that that's a very clear answer to your question, but it's unfortunately not an easy question to answer. So I think the bottom line is that the assessment needs to be done entity by entity. I will remind you that the activity trigger, so the importing into Canada or the producing, selling, or distributing goods, that still needs to be performed by an entity meeting the entity definition. So if you're a parent company that does not buy and sell goods or produce goods and does not import into Canada, and your subsidiaries that are doing those activities don't meet the entity definition because they're not big enough, then you would not be an entity controlling an entity that's engaging in those activities. So it is a bit of a rabbit hole of kind of, and that's why we had the flow chart up above to try and help companies work through that if-then assessment. But it's certainly not an easy question, and a lot of companies have been and are struggling with this, particularly in this first year when everyone's trying to understand the scope of the obligations and determine whether they're going to be expected to report or not.
Absolutely, absolutely. Thank you, Jessica. Okay, we actually have two that are very similar in regard to supply chain mapping. So is it mandatory for the companies to do supply chain mapping? I'm just going to jump to the other question in regard to if yes, is it for all the suppliers or only those who have been identified that are as a risk?
So the answer is no, it's not mandatory. So I go back to my initial comment about this being reporting legislation, it's not due diligence legislation. And I don't think I mentioned that as part of the mechanical process of actually submitting the report, you will be required to complete an online questionnaire that Public Safety put together that is designed to help guide companies through the contents of the report and make sure that the contents of the report tick all of those boxes from Section 11 of the legislation. The contents of the online questionnaire will not be published, but I will caution you that they are not treated as confidential. So while the government has said that they are not publishing the responses, that doesn't mean the government can't use the content in those responses for some other purpose, like for its own internal reporting or for parliamentary reporting at a later date. So just to keep that in mind, that you want to make sure that the content of your online questionnaire is consistent with the content of your public-facing report, or at least not inconsistent, and that you don't have any confidential information in there. But the reason I'm bringing up the online questionnaire is because if anyone's been on the Public Safety website and taken a look at it, you'll see that there are some questions that are seemingly very prescriptive. Like it says, which of the following due diligence activities have you engaged in the past year? And one of them is supply chain mapping activities, and you're supposed to tick if you've done it. And the way that the question is framed seems to imply that you're supposed to be doing all of these things and that it's a checklist and you need to check them all eventually. That is not the case. The law does not require you to do any of those things. That list is simply an illustrative list of some of the types of due diligence elements that are present in best practice forced labor and child labor compliance programs. And my guess is that Public Safety is collecting this information both for its own statistical reporting, so that it can say in its report to Parliament, well, 42% of respondents said that they mapped their supply chains, and then in the next year's report they say, well, the number's now up to 53%, so we're seeing an improvement. That's, I think, the reason why they're trying to collect that type of information, but there is nothing in the legislation that says that you need to do any of those things. And so which of those items are going to be desirable for your company to do will again depend on your specific risk profile. And I will say, with respect to supply chain mapping, and all that refers to is just informing yourself about where your products are coming from and where the raw materials that go into those products are coming from, to the extent that you are able to access that information, because that information might not be something that you necessarily know because it's confidential to your supplier and your supplier doesn't want to share that information with you. But the purpose of a mapping exercise is to try and get as much intelligence as you can get your hands on so that it can inform your risk assessment. So to Al's point, it's understanding what your supply chain looks like, what jurisdictions it touches, what type of activities are involved in it. Is it manufacturing? Is it services? Is it sales and distribution? Is it international logistics and shipping? What are the types of labor and employment roles that exist within your supply chain? And that will help you identify where the risks of forced labor and child labor might be the highest. And then from that risk assessment, you can appropriately design your due diligence processes to target the highest risk areas in the most cost-efficient way possible.
Wonderful, thank you. Okay, we've got a two-part question here about due diligence. So since the Act has within its scope the selling of goods in Canada or elsewhere, do the requirements extend the due diligence to our customers as well? And the second part to that question is, when can we expect a potential due diligence act to be enacted in Canada?
I'm not sure I can speak to the latter one. That might be a good question for a policy specialist. But I know that there are discussions in Parliament. There have been draft legislation tabled going back now probably about 5 years. There's been various different iterations of proposals, and this is something that the federal government has said is a priority for them. In the 2023 budget, the government indicated that they would be developing due diligence legislation. I think they said within the next year, although I'm not sure that we've seen anything yet. So I think it's a watch this space kind of answer, that as long as the legislative imperative is there and the policy interest and desire is there on the part of lawmakers, there will continue to be discussions, and we may eventually see something, but I couldn't tell you when exactly that will happen. And Maria, sorry, what was the first part of the question? It was about do these obligations apply to our customers?
So since the Act has within its scope the selling of goods in Canada or elsewhere, do the requirements extend the due diligence to our customers as well?
So first of all, there are no due diligence requirements in this Act. I think I've said that about 5 times now. So that's just one thing to keep in mind. In terms of the reporting obligation, whether your customer has its own reporting obligation will depend on its own assessment of whether it's an entity under the Act and whether it's engaging in any kind of activities that would trigger a reporting obligation under the Act. In terms of the import ban, it is conceivable that, so customs laws are what lawyers call an in rem law, which means that the law applies to the product, not the person. So if a particular shipment of goods is determined by the CBSA to have been produced by forced labor or child labor, those would be classified as prohibited goods that cannot remain in the country. And so they would need to either be destroyed, re-exported, or if they've disappeared into the commerce of Canada and it's not possible to get them back again, there are mechanisms under the Customs Act that allow for what's called ascertained forfeiture, which is essentially a financial penalty on either the importer or the owner of the goods. And so that's where your customer could come in, is that if they're the owner of the goods, because these import ban laws apply in REM, conceivably the customer might have to give up the goods as well if it's determined that they are prohibited and that they can't stay in Canada.
Thank you, Jessica. Okay, so we want to be respectful of everyone's time. We do have quite a few questions that are outstanding. However, I promise we will follow up individually with all of you with answers to your questions. So we're almost at the hour mark here. I'll wrap it up. I just want to thank everybody for attending, and a big thank you to Jessica for coming on as our guest speaker, and Al for providing both of your expertise and knowledge to help us better understand this Canada's Supply Chain Act to combat forced and child labor. With that, I want to wish everyone a great day and stay safe. And we will conclude our webinar for today. Goodbye.